I just wanted to welcome everybody here to what will be our practice for the year. Another Zoom meeting. For those of you that haven't had Zoom meetings, welcome to your very first. For those of you that feel like I am, that you're living your life through Zoom, welcome to yet another Zoom meeting where you get to see 12 people on a screen at one time looking at you as you try to make eye contact. And I'm still horrible at this. I look at the faces on the screen. I never look up at my camera. My backgrounds never look good. It is what it is. But welcome everybody. I know we contemplated whether we were going to have this meeting tonight, given the fact that it is a national holiday. And I do want to take a moment out to thank those members of our inn that are veterans themselves that have served in the military. I want to thank you for your service. And for those of you that have friends and family members, we thank them as well. It's part of what makes this country great. And I'm so excited that we have a day like today where we get to stop for a moment and try to remember those people who have served in our military. It's a different day than Memorial Day. It's not just for the people that have lost their lives in service, but it's for anybody that served in whatever capacity in our military. So I thank all of you for that. Let me ask for my group whether we've got any comments. I'll start with Eric Novell. Do you have any comments as membership chair? Eric.
Yeah, just for a moment, Judge Washington, I'd like to remind everybody that once a month we meet, and we have right now 32 attendees and 12 panelists. That's 44. If we could all try to reach out to one person in the North County and bring a guest and kind of introduce them to this organization and to the environment. I know it's a strange time because we're all Zooming and teaming and whatever it is. It would be really helpful, and it would be a good introduction so that when we ultimately do get back together, we can meet one another, and it'll be that much more fun and it'll be that much better. So for the next meeting, let's try and do that. I'm going to try and do that. Let's all kind of pledge to do that. But other than that, Judge Washington, thanks for leading this, and I'll let it go at that.
Great, thank you. Let me turn next to our treasurer, Randy. Or do you have any presentation about where we stand financially given our status during this pandemic?
Yes, I could just encapsulate it this way. We have really incurred only the following bills so far this year: national dues, about $6,000 or $7,000. And then we've got some other miscellaneous expenses, pretty minor. So we're doing okay because we had a fairly decent reserve built up from last year, from prior years, actually. However, we're not spending the kind of money we typically do on renting the room at the senior center or on meals. So our outflow is pretty reduced right now, quite reduced. On the other hand, we do have a discussion going on within the executive committee now, and we don't have a final decision on that, but we will soon. It's on my to-do list to agree on a reduced due structure for this year to just cover what we expect to incur this year out of the dues, and then send out invoices, collect those dues, and then we'll move forward next year, hopefully, with our normal budget. So right now we're working on a reduced budget, which is okay from the treasurer's perspective. We're not running out of money. And I will be sending out invoices as soon as the executive committee makes their final decision. Okay?
Great. Thanks, Randy. And just to follow up on that, the fact that we're not running out of money is something that the president of the inn also appreciates, that we don't have that concern as we go through the rest of this year. For those of you that haven't followed the news, you might not be aware that San Diego County went back to purple tier, which again imposes more restrictions on businesses and the types of activities they can have indoors. It's possible that San Diego can get out of that tier by the 1st of December and get back to, I think orange is the next lower tier from that. But it's probably not going to change what we're going to do as an inn. I'm anticipating that all of our meetings through the end of our term in June are going to be these remote Zoom meetings. I don't anticipate that we're going to have access to the Carlsbad Senior Center at any time until at least the middle of next year. And for those of you also that didn't follow the news, there have been some encouraging reports both here in the United States and overseas about vaccines for the coronavirus that might be starting to be available by the end of this year to those in particular need, healthcare workers and high-risk individuals, and then by next year to the general public. Obviously, if that's in place by the middle of next year, then that will greatly change what our options will likely be going forward. And so I want to echo Eric's comments that this is a great time for people to be safe. If you have friends and colleagues that you think might be interested in just coming to check us out, this is a perfect time to do it. They can do it from the convenience of their home. I recognize that it's a very different experience than what our inn truly is. What I love about our inn when we meet at the senior center is that first 45 minutes of sitting down and greeting people that you might not have seen in more than a month, getting a chance to break bread with them. And this is not quite that environment. And I haven't figured out a way to make this more like that. I don't know that there really will be, but this is still a time for us to get together and share what we know about the practice of law. And that's why I'm really excited about the topic tonight, because this is something that, you know, I know this is Judge Elias's group, but as judges, we deal with this all the time. And as lawyers, sometimes you deal with it as well. How to ethically deal with difficult clients, right? And litigants. And so with this, I'm just going to go ahead and turn it over to Judge Elias and let you take it from here. Judge Elias? I think you're muted.
So I'm going to turn over to Howard, who's going to sort of do the intro and lead in to our program.
Okay. Well, good evening, everyone, and thank you so much for joining us, and welcome to Team One. We looked at a subject which is all around us and something that's a matter of public knowledge, but it has crept slowly but surely and definitively into our practice. And that is the reduced levels of civility between lawyers, clients, and sometimes lawyers' relationship to the bench. And so that we as lawyers need to be mindful of the importance of our role. And our role is to advocate and present best for our clients. And in order for us to do that, we have to recognize that a lack of civility, in this particular circumstance we call bullying, is something that exists, persists, and we have to address it so it doesn't continue to mar what is otherwise an honorable and good profession in the service of the public. Now, we were all school children at one time, and we remembered that there were schoolyard bullies who may have pushed you off the slide or made you fall down or used some difficult language or tried to humiliate you. And we know that it's an unfortunate part of the growth of children that from time to time bullying exists. There's even a stopbullying.com on the California website. So it's something that has grown to public importance so that we know from our school children to our retirees, it's something that we all have to deal with. Now, bullying can be a personality trait. It could be that someone grew up that way. They were taught that way. Bullying is not a genetic disorder. It's something that is acquired. It is something that is learned. It is a process of trying to power over someone else. And we know that if left unchecked, it leads us to bad results, both for ourselves individually, for the clients that we represent, for the community that we serve, and to the bench that we owe our highest duty to. Now, bullying can also be, and is often now more seen as a tactic. that someone who is a lawyer or a client or someone involved in the legal process tries to exert undue power and pressure on another to create a result favorable to them and to the detriment of who they are targeting. In this circumstance, we as lawyers stand as a safeguard for our clients, but we also have to safeguard ourselves from our clients if they turn into the bullies. So we need to look at bullying from the outset. From the standpoint of our clients, we need to interview them carefully to learn about them, to learn about their characteristics and personality traits, to do some due diligence. For example, to go to San Diego Superior Court.gov and find out whether or not they've been parties to lawsuits. I did it one time and found somebody that had been in 28 lawsuits in less than a year. So it's something that you can find by having some level of diligence and looking at public records. But you as lawyers know in your gut, more often than not, when you've got a problem client, you're the third or fourth lawyer that they come to in a case. They are someone who has a history of payment problems. They are someone who has been outspoken, who has been disrespectful. When you have clients like that, those clients eat into your other clients' work, which is more valuable, and it eats into your persona as a person and as a professional. So if you have a bully that's in your office as a client, borrow Nancy Reagan's phrase, just say no. Don't get involved in representing a bully to begin with. But sometimes in our practice, someone comes in as Snow White and they come back as the Wicked Witch of the East. Sometimes our clients morph in front of us to be someone whom they did not present themselves to be to begin with. It could be in things that they hid. It could be in documents that they didn't produce. And tonight we're going to go through an exercise like that where there are bullies all around, and it's not just the opposing counsel. But we know that opposing counsel sometimes try to take advantage of lawyers. It could be someone trying to take advantage of a lawyer because of their youth or their gender or some other accident of birth, or just because they happen to like to do it. It may be something like that. And we all know as lawyers, and we can smell when someone doesn't want to give an extension, when someone doesn't talk to you in a respectful manner, when you receive emails and correspondence that are highly inflammatory and disrespectful, that there's a bully on the loose and you're the person who has to deal with it. So what do we do when we encounter bullying? What do we do when we encounter a lack of civility? What do we do as lawyers to protect ourselves, our firms, and our clients against these practices? First of all, we have to acknowledge that it exists. We have to recognize that it's unlikely we will go through our careers with a pristine record of never having a crossword with an opponent or a client or a witness. We have to recognize that it's part of life, much in the same way as it's part of the playground of school children. It's something that happens, something we try to minimize, but something that we can't avoid at all times. So we need to come up as lawyers with a strategy. How are we going to deal with this? What is our best play going forward to help ourselves, our clients, our community, and the officers of the bench to whom we owe one of our highest duties? It's important for us to keep in mind that sometimes containment of communication is the best way to start. When we have communication with a bullying opposing counsel, we need to define where we're at and how we're going to best put these communications into their proper perspective as we go forward as attorneys for our clients. For example, one idea is to have phone calls which are joined by one of your partners or colleagues so that they can listen in and also be witnesses in the event there is a need for a declaration or for a discovery motion or other proceeding before the court. You may also want to think of a time of day. I'm going to allow this communication only between 9 and 9:30 in the morning each day or at the end of the day, so it doesn't dominate and ruin what is otherwise a productive opportunity for your professional endeavors because it dominates your thinking. It's also important to document these communications. We live now in a time of email, instant communication, where we can, at the push of a button, document and communicate with one another. But that is a double-edged sword. We don't, as attorneys, want to engage in the same anger, bullying, or disrespectful tactics that an opponent would do. For example, think before you push that button. Think of whether or not this is going to advance your client. Think of Judge Elias, Judge Washington, or another judge reading that email that you're responding to. Think about where it puts your client. Is it strategically in the advancement of your client's interest? Sometimes a pause is better than a push on the button. We also have to recognize that sometimes these tactics permeate not only communication, but discovery proceedings. For example, depositions, court hearings, other types of written discovery that exchange between counsel in a case. So if you have a bully who's an opposing counsel, think about videotaping the deposition. Think about getting a court reporter for the hearing. Thinking about how best to couch your meet and confer letters regarding discovery. You need to collect the evidence for the court to act on it. But in the absence of the evidence, the court is not going to be doing a toss-up on a swearing match. But if you have a series of emails, correspondence, and communications which show disrespectful and bullying tactics beyond the scope of what is appropriate in advocacy and an overt action to exert power over another, any judge will be able to pick up those crumbs and put together the story as to why this came before them. So some ideas that you might want to consider is to limit your communications to email. Make your emails short, sweet, professional, and factual at all times. Think about keeping your staff advised about this particular lawyer or this particular case. I've done that. I have directed all communication regarding particular cases to myself or to a select number of people who know what is going on and document it. Think about advising your partners and other people to get tips on how best to deal with someone like that. And realize that it's not only what you communicate, but how you communicate that counts. Never stoop to the level of a bully in the representation of your client and the maintenance of your integrity as a professional. Be someone who does the right thing even when it's tough to do it. That is really what we're called upon to do. We may not turn somebody around by our example, but we can, by example, turn around these events and make them something that we can use as a point of advocacy for our clients. Some additional tips that you might want to think about. If you're going to a settlement conference with someone who's a bully, think about coming with a settlement agreement so that if a settlement is reached, you can document it then and there without having a handshake and then a bunch of other bullying emails and phone calls saying that the agreement did or didn't include something which you know is not true. Make sure that you document such things because you might otherwise create a problem for your client or your firm or your practice later. think about whether or not you have a bullying client that you can't control and you can't represent. There comes a time, it's not simply about non-payment of bills, it's about your sanity in representing someone. If you have a client who is a total bully, dishonest, hiding documents, and being disrespectful for you, that person's not going to get any better. And you have to decide when it's time to cut the cord, file a motion to be relieved as counsel of record or substitute out of the case. Never let a bully continue to run your practice, and ruin your life. Now, as we go through our vignettes and examples tonight, think about your own cases. Think about the cases that you have which have discovery problems, which have clients that aren't fully forthright in producing documents or telling you truthful information, about situations that have evolved in the past or are evolving now where you can make a difference. Regardless of what you did up to this moment, you can turn and make a change to act more professionally, to act in the interest of your client, to make sure that you don't stoop to a lower level that this bully is trying to drag you down to, and to collect the information you need to make motions, to obtain relief, and to advance the interests of your client. Judges themselves have duties also to control the proceedings before their court, to exercise reasonable control over proceedings, to be able to ensure that the truth prevails and that justice is served. When you give the court 10 or 15 emails which show a continued pattern of bullying and dishonest behavior, that is much better than simply a declaration based upon your memory. So give the court the opportunity to exercise its powers so that it can act in the best interest and integrity and independence of the judiciary. We now turn our efforts from the general to our more specific examples. And I turn over now my discussion to Federico, who's going to introduce our case, our characters, and how we're going to move forward from here.
Hi, everyone. Today, we have put together 2 skits that will illustrate you a bullying situation in and out of the court. After my introduction, you will see a representation involving facts, the interaction of attorneys, parties, and ultimately the court dealing and addressing bullying. Our case is called Mason versus ABC Corporation. On our first skit, named The Deposition Gone Awry, Mr. Calico Jack Beard is the senior vice president of ABC Corporation, a small company of about 10 employees. He and his company have been sued for sexual harassment and wrongful termination by a former female employee. The first round of written discovery has already taken place, and Mr. Calico Jack Beard is being deposed. The characters here are Mr. Aaron Burr, who is the plaintiff attorney, and he is the one who is taking the deposition. Mr. Burr will be played by Stephen Lopardo. Mr. Calico Jack Beard is the defendant and deponent. Mr. Beard will be played by Stephen Mediaris. And finally, but not least, Ms. Alexandra Hamilton, who is the defense counsel, and who is also defending the deposition. Ms. Hamilton will be played by Rima Curry. Okay, so now we can start with the deposition.
Rima, you're mute.
All right.
All right, we're back on the record. Mr. Beard, do you understand, sir, that you're still under oath?
I do.
Okay. Do you recall having a conversation or any sort of communication with plaintiff Ms. Mason regarding her chances for advancement in your company?
I'm almost certain we did at least 2 or 3 times, but no specific discussion comes to mind at this point.
Well, do you recall giving her any advice or any guidance on what she needed to do to move ahead in your company?
I probably told her to keep working hard like she's been doing and to keep her quality of work high, and the opportunities will eventually be there.
All right, well, putting aside any such advice you gave her about your job performance or her job performance, did you give Ms. Mason any suggestions on what she needed to do in order to get a higher position in your company?
No, nothing comes to mind.
Do you recall advising Ms. Mason not to do or say anything as part of a conversation in order to move up in your company?
No, can't recall anything.
Mr. Beard, I'm going to mark as Exhibit 23 a document here. I'll give you a second to look at. I'll give a copy to your counsel as well. You recall seeing this document before, sir?
I don't remember writing it offhand, but it looks like it came from me.
Well, sir, I'll represent to you that this is a copy of an email sent from someone named James Beard. There's your name, isn't it? To someone named Hannah Mason, as in the plaintiff, dated April 25th, 2018.
Yep.
And according to this email, James Beard's email address is jbeard@abccorporation.com. That's your email, isn't it, sir?
Yes, it is.
Okay, and it was sent to an address at H Mason, that's HMASON at abccorp.com. Now that's Ms. Mason's address while she worked at your company. Isn't that true, sir?
Yes, I guess so.
Okay, I'm going to read into the record from Exhibit 23. This is a quote, sir. It's from Exhibit 23 from you to Ms. Mason. Quote, "You definitely have the chance to become one of the higher ups in this company, but keep in mind that the high ups in this company are a bit of good old boys club. So you're going to have to deal with some crudeness by the guys from time to time, both in the office and after work when we go out to a bar for a drink. Some of the guys are going to flirt with you and joke around a bit. Just roll with it. Pretend that you are having fun." End quote. Isn't it a fact you wrote that, sir?
Yeah, I guess so.
All right, I'm going to continue to read. This is from the 4th paragraph, Exhibit 23, quoting, "Whatever you do," and this is from you, sir, "whatever you do, don't discuss these interactions with anyone in the company outside of me or the other VPs. If HR finds out about this, we are all going down and we are taking you with us." And
Counsel, can we go off the record for a few minutes?
now, before we go off the record, Ms. Hamilton, I have a question for you. Ma'am. Why wasn't this email produced as part of the written discovery?
Well, I don't recall ever seeing that email before. It could have been an oversight by my office.
Well, it must have been a heck of an oversight here, Hamilton. My client printed out and kept quite a few text messages and emails that Beard sent her. Your client Beard sent her during her final year at ABC Corporation. I have about a dozen emails and text messages here that say similar things, and not one of those were produced during discovery.
Oh boy. I'm not sure.
Oh boy. Oh, yeah. Well, there's got to be some sort of explanation here. Tell me, Hamilton, why is it that your client produced 800 pages? 800 pages of emails and text messages a few weeks ago most of which have zero relevance to this case, and not one of the pivotal emails in this case were produced, especially when the request for production was very specific about what communications were being requested.
Well, oh my God, I'm not
Hamilton,
sure.
let me just be straight up. I'm going to go in front of the court. I'm going to go to the judge. I'm going to make a motion to compel. I'm going to have the judge appoint a discovery referee here. There is no freaking way that your firm can be trusted to comply with its discovery obligations under the law. The judge is going to teach you and your client a couple of tough lessons that you're not going to forget. You know, people like you are an absolute disgrace to our profession. It's lawyers like you and others in your firm that make people hate and distrust lawyers. You're well on your way to becoming the poster child for bad lawyers. And people like my client, Hannah Mason, deserve and are entitled to justice for the wrongs that have been done to them by scum like your client. I don't know how you live with yourself representing this filth. Their sliminess rubs off on you and other defense attorneys. It's like the old saying says, you lay with dogs, you get fleas. If you want to fight about the facts and the law, fine. It'll be a fair fight. We'll fight about the facts and the law. But intentionally withholding evidence, really, that is a jackass move on your part. If the facts aren't in your client's favor, then hurry up and settle. Withholding evidence and dragging this out so you can bill more attorney's fees, that is absolutely despicable. With that, we'll go off to the record.
Beard, let's go outside to chat.
Sounds good. Hey, how close are we to lunch?
What the heck happened to those emails and texts? Why weren't they turned over to me?
Oh, relax. Everything's going to be fine. Look, I've been in all kinds of lawsuits where a company that I've worked for has been sued. I know the game. Most cases settle. Any lawsuits that I've ever been involved with have settled. This one's going to settle too. This case will never go to trial. Mason and her lawyers are going to get some money soon.
Okay, all right. You're not answering my question. Why didn't you turn those documents over to me?
Like I told you, this case is going to settle probably soon. If they never, if those emails, the case would have settled for less. So great for our company. But heck, we got caught. So we'll end up settling for a bit more. That's all there is to it, Hamilton. It's going to be fine. Don't sweat it. It's just a game of strategy.
It's not a strategy. It's dishonesty. You signed a verification under oath saying that you provided accurate responses to their document requests.
Well, that's the way we play the game.
Well, Mr. Beard, you just don't get it. Litigation isn't a game. Lawyers have ethical responsibilities to uphold, and during the discovery process, clients have to attest to their responses, that their responses are truthful and accurate.
Well, like I said, it's a strategic game.
All right. I think Burr goes next.
Beard?
Oh,
Burr?
okay.
Anyway, we're back on the record one way or the other. And I'll tell you, Hamilton, you should buckle up for a bumpy ride. Because I have a stack here of all these emails and texts from your client to the plaintiff, Ms. Hannah Mason, which you guys in your infinite wisdom refused to produce. And I'm going to be asking him about every single word and every single line in every single one of these exhibits. Thank you very much.
Okay, so the following skit is called the motion hearing. Here, Mr. Burr has filed a motion to compel a series of documents that Ms. Hamilton's client is refusing to turn over. Mr. Burr moving papers includes several paragraphs where he excoriates and ridiculizes Ms. Hamilton. Here we're gonna have Judge Elias playing as himself, Mr. Burr, plaintiff's attorney, played again by Steve Lopardo, and Ms. Hamilton, defense counsel, played again by Rima Curry. All rise. The court is now in session.
Okay, good afternoon. Let's go to the next matter on the calendar. Mason versus ABC Corporation. This matter is a motion to compel concerning documents sought by the plaintiff from ABC. Counsel, would you please state your appearances?
Good afternoon, Your Honor. It's Aaron Burr for the moving party and the plaintiff.
Good afternoon, Your Honor. Alexandra Hamilton for the defendants.
Thank you, counsel. I want to start off by saying that I'm a little bit concerned about some of the things in this motion. And to be blunt, I'm not very happy about them.
Your Honor, I really don't see why you're not happy. Certainly shouldn't be happy with me, other than the fact that the University of Michigan Wolverines is 1-2 this year against terrible competition, and you can't run and you can't pass and you can't block and you can't tackle and you can't kick, and for that matter, you can't even punt, but that's neither here nor there. My clients and I are victims of some very serious discovery abuse here. We're here today because of some shady lawyering by my opposing counsel, Ms. Hamilton. So there's no reason to be out of sorts with me, Your Honor.
I ran track, Mr. Burr. I didn't play football. And by the way, I'm not condoning what Ms. Hamilton's clients have done here, and perhaps Ms. Hamilton could have handled the situation better than she did. But I think the personal attacks on counsel are not necessary. Your moving papers do set out both the facts and the law. That's all I need to decide the issues set before me today. But for some reason, you felt compelled to include in your paragraphs of both editorializing and grandstanding, in which you tore into Ms. Hamilton. It seemed clearly to me like an attempt to bully her, at least on the surface from the documents. You should be able to prevail on your motion without any of this extra stuff. None of it was necessary and certainly doesn't do anything to help sway me in my decision.
But Your Honor, Ms. Hamilton needs to be taught a lesson. Attorneys have an ethical obligation to uphold, and Ms. Hamilton, not me, Ms. Hamilton has made a mockery of them in this case by going along with her client's refusal to hand over validly requested documents. And in order to teach her the right lesson, the court really needs to understand how out of line her conduct was with regard to this document production.
All you needed to show, Mr. Burr, is what documents you knew existed because you had them, and counsel and her client failed to produce them. Stick to the facts, stick to the law. There's no reason from my perspective or any justification for personally attacking or tearing Ms. Hamilton apart in your points and authorities. Any lessons taught should be legal, not personal. Also, some of the emails that you wrote to Ms. Hamilton, which you attached to exhibits as part of your declaration, were way over the top. It appeared to me that your emails to Ms. Hamilton were both intimidating and harassing. I also have the transcript from your deposition of Mr. Beard. What purpose does it serve to tell Ms. Hamilton that she's a disgrace to the legal profession, or that she's become a poster child for bad lawyers, or calling her despicable? None of it was necessary, Mr. Burr. It was way out of line. I don't know what you thought you were going to achieve by saying these things. You didn't need any of this to help you with your motion to compel. So why do it?
But Your Honor, if it pleases the court, I didn't say anything profane. I didn't say anything nasty. I didn't say anything obscene in those emails.
It's true. You weren't profane. You weren't obscene. I'm not so sure about nasty. However, counsel, you might be aware of a case earlier this year when a federal district judge up in LA imposed over $17,000 in sanctions against the lawyer who sent profane and threatening emails to his opposing counsel at Shepard Mullen. Now, your emails to Ms. Hamilton were nowhere near as bad as the ones sent by that attorney in LA. But that doesn't mean that any communication that isn't profane, isn't obscene, or isn't threatening is appropriate. One can bully another person without being profane, obscene, or specifically threatening. Counsel, and this applies to both of you, the judicial canons of ethics require me to conduct all proceedings in a courtroom in both a dignified and courteous manner. Not only is it a requirement, but it's also the right thing to do. And that's how I've been conducting court hearings and trials for nearly 3 decades. I hold all the lawyers who appear before me to the same standard. Your moving papers and your emails to Ms. Hamilton were, in my opinion, way over the top and fell far short of this standard. I expect better of you, Mr. Burr. You've appeared before me before. You're highly skilled and competent. I don't want to see or read words like this coming from you ever again. Do you understand me, Mr. Burr?
Yes, sir. Yes, Your Honor, I do.
Now, let's discuss some of the merits of the motion. It appears that the RFP was very clear in the subject of documents being requested. The response to that specific request stated that no documents were being produced because no such documents ever existed. Counsel, am I correct so far?
Yes, Your Honor.
Then on the day of the deposition, Mr. Burr shows Mr. Beard a stack of documents that he obtained from his client that clearly would be responsive to the requested issue and part of the documents in the possession of ABC Corp. A few days after the deposition, Mr. Burr sends a meet and confer letter to Ms. Hamilton, demanding that she do an amended response to the RFP and that she then produce the responsive documents. Nothing occurs, and Mr. Burr then files his motion to compel.
That's correct, Your Honor. And Ms. Hamilton did not produce any documents in response to the plaintiff's meet and confer letter. She also did not serve an amended RFP response.
So, Ms. Hamilton, I read your papers in opposition. You didn't offer any legal justification as to why no documents were produced.
That's correct, Your Honor.
So I've reviewed the documents that Mr. Burr introduced as exhibits during the deposition. They're not privileged. There's clearly no legal basis for not producing them. Therefore, a motion is granted in favor of the plaintiffs. Defense counsel shall have 30 days to serve plaintiff's counsel with an amended RFP response in all of the responsive documents. Now, Ms. Hamlin, let me turn my attention to you. I'm going to sanction your client in the amount of $4,200, but I'm not going to sanction you at this time. In light of what you've had to deal with, both from your client and from Mr. Burr, it seems to me imposing any monetary sanctions on you will be rubbing salt in the wound. It's not my place to give you any legal advice or tell you how to represent your client. But if you plan to continue representing your client, you and your firm need to have more control over your client during the litigation.
I understand. Thank you, Your Honor.
Thanks to you both. I don't want to see a situation like this again during the balance of this litigation. If I do, I'm likely to impose some sanctions against either the parties or the attorneys. No one is immune. Have a good day.
Thank you,
Thank you, Your Honor. And now we go to Randy. Randy is going to go over dealing with difficult people.
Yes, hi, everyone. I hope, well, I was going to try and show a slideshow, but that's not going to work. What I am going to do is run through a short outline of a really interesting book that I acquired some time ago. I'm going to hold it up so people can see it. It's called, wow, can't even see it on the screen. Here we go. High Conflict People in legal disputes. It's not coming through at all because of my background. Hang on, let me fix that.
Randy, if you put it in front of you, it's gonna appear.
Oh, nice. Okay, you're right. Thank you, Franco. High conflict people in legal disputes. It's a great volume, and it teaches us how we can deal with certain personality types, two of which I feel are illustrated in this vignette. There are 4 kinds of high conflict people, as the author Bill Eddy describes them. Bill Eddy, by the way, is a licensed social worker. He is a licensed LCSW. I think that means well, it's a social worker. He's also a lawyer, so he's dealt with counseling people with personality disorders as well as an attorney. So there are 5 kinds of high conflict people. One he calls borderline personalities. He describes those as people who love you and then hate you, not very reliable. Narcissistic personalities who think they're very superior. Con artists who use deceit to try and get ahead. Histrionic personalities who are always dramatic. And then there are the enablers, the people who kind of participate in the process, including lawyers, who don't have either the time or the courage to stand up and say, wait a second, what's going on here? We've got to get real. Some of the common behaviors that he illustrates in the book are what's called wish-driven thinking, very common, as opposed to reality-driven thinking. People who want the outcome to affect the reality instead of the other way around. People who use manipulative speech and actions, people who are delusional. And he says that we as lawyers play an important role in controlling this type of behavior. We are the gatekeepers. We are, and here's what he says, that allowing parties to go to court without testing their facts and fantasies does a disservice to the party, to the court, and to society. The court's time is precious. So is our time. We're engaged in the business of dispensing justice. But when people come to court or to us and waste our time, then we can't do our jobs. As Howard said earlier in the introduction, we have better things to do than to be babysitters for people who can't act in a mature and responsible way. Here is one of the tools that Mr. Eddy mentions. It's called reality testing. He calls it one of the key issues for dealing with high conflict people. When a dispute is eventually resolved involving a high conflict person, he says, it is usually due to sufficient reality testing. You've got to constantly be vigilant, and you've got to constantly push back on what your client is telling you if you're dealing with a difficult client. Here are some more skills that he outlines in the book. Always maintain healthy skepticism. Keep an open mind. Resist the high conflict client's misinformation. Push back on their assertions. Do it in a way that is respectful. He says you should never terminate the relationship abruptly. You should always be respectful, but push back. Suspect lying. Recognize cognitive distortion. Learn the realities. In other words, as Howard said in his intro, do some research on the client. And what else? We're getting near the end here. He also talks about 4 steps in resolving high conflict disputes. There's bonding. This is where you create a trust with the high conflict person. You bond with them. You spend time with them. You relate to them. The second step is structure. High conflict personality people lack structure, and so you as a lawyer can provide that for them. Reality testing. We talked about that. I talked about that earlier. Most high conflict people tolerate one view of reality, their own view. And you as the lawyer can say there are other views and you've got to deal with these. And then finally, consequences. As illustrated in the vignette, there were consequences for Mr. Beard. Mr. Beard was assessed a penalty of $4,000, monetary penalty. There were also consequences to the lawyers. And I'm going to go ahead and do a little bit of amateur psychology here. I'm going to place, and I don't know if anybody can see this. This is a, here we go.
There. Have it in front of you.
It was there. This is a chart that Mr. Eddy prepared, and it's got all 4 personality types at the top. He's got the
borderline narcissistic,
yes,
antisocial,
and
histrionic.
Right. So what I did is I circled the 2 that I think apply to the main characters in the video. I'm thinking that we've got an antisocial personality with Mr. Beard. He's dominating, he's manipulating, he's controlling, and he's deceiving. And a lawyer in Rima's position has got her work cut out for her. She started that process during the break. She said, "You can't do this. This is crazy. We've got to be real here." And then we've got the lawyer, Burr, who I think fits the histrionic disorder or the histrionic personality. He's creating drama. That's what it says here. Always seeking attention and drama, relying on emotionalism to try to make their point. And he's got in his book ways to deal with these personalities. So I would recommend you pick up the book. I hope that we have some of these materials available in our handout, because they can be very interesting to see what you can understand about people who are dealing with these psychological issues. And it's our job as lawyers to be the gatekeepers.
Thank you, Randy. I think that's the conclusion of our presentation. Howard, did you have any closing words? Otherwise, I was going to thank the entire team.
Well, I just want to emphasize that when people are involved in litigation, there are very strong emotions. And you have to separate the emotions from the facts, and you have to reduce the temperature in the room and do your own due diligence to determine what is and what is not appropriate and what is not supportable as truth. And we all would like to believe our clients 110%, but we know that we believe our clients a lot less than that, and our job is to separate the wheat from the chaff. And we also have to give them a mechanism in which to cope with their emotions, and that is try to build in some time for them to understand that a lawsuit is not something unique to them, but something that happens every single day, and that their role as a client is to be as efficient, truthful, complete, and accurate to help you as their lawyer going forward so that you can get the best result for them. Rima,
Yes.
You're on.
So I just wanted to let everyone know that these handouts were sent out to everyone through Susan Curran. And if you didn't get them, please follow up with her. This is this MCLE presentation was satisfy one legal ethics credit, so that's a very valuable one. And I just wanted to thank our entire team here, Judge Elias, Howard Franco Jr., Randy Ortlieb, Louis Starro, Steve Lopardo, David Dafferty, Stephen Medeiros, myself, and Frederico Lathrop. And a special thanks to David Dafferty for the screenwriting of this production, and Lou Starro for the producing and directing. Thank you, everyone. We're trying to keep this very timely and within an hour. So we appreciate your time. This is the first of our Zoom presentations, so we hope that you enjoyed it. Thank you very much.
Have a good evening.
Yeah, and I think we'll hand it over to Judge Washington.
All right, great job to Team One. Way to get us off to a great start for this
Yes.
term. You've raised the bar for everybody else, so we're looking forward to what the remaining teams can do in the upcoming months. But you guys got us off to a fabulous start, and I just echo the comments that you guys made. It's all about let's work together to make sure we handle ourselves in a way that brings honor to our profession. So have a great evening, everybody. Thanks for joining us on a federal holiday. We'll see you in a month.